in order to improve our chances of winning. Tragically, in the final analysis, exclusion of certain voters is the premise of what voter ID is all about. Now, I'm a lawyer and a prosecutor, so bear with me, but I believe in our laws, and I believe in our Constitution. Article 7 of our Constitution has 9 short sections. The first lays out who can vote. People who are over 18, citizens of the United States for 3 months, and living in their particular precinct for at least 30 days. There are a number of people that the Constitution excludes. Those convicted of a felony until the civil rights are restored, a person under guardianship, or a person who is insane or not mentally competent. We should, in my view, be very hesitant to change our Constitution. We should be even more hesitant when the change will restrict the right of some to vote. A democracy, in my view, by definition, functions best when as many eligible voters as possible vote. The Minnesota tradition has always been to do everything possible to facilitate the ability of eligible voters to show up on election day and cast her or his ballot. On a bipartisan basis, we've passed laws that set up election day registration and made absentee voting an option for those who cannot physically make it to the ballot box. The result? For at least the last 3 presidential elections, no state has had a higher level of civic participation, and I'm darn proud of that. Minnesotans not only turn out to vote in large number, they do it honestly. Visit any polling place and you will find a real sense of community. People patiently standing in line, chatting with their neighbors, and proudly putting on their I voted stickers when they leave. As Hennepin County Attorney, it's my job to review our elections for any irregularities, and I take that part of my job very seriously. In the 14 years I've been Hennepin County Attorney, there have been no cases of voter impersonation. There have been no organized fraud or manipulation of voting. None. Let me repeat. In 14 years as Hennepin County Attorney, we have seen no cases of voter impersonation. There have been no organized fraud or manipulation of voters. None. As a prosecutor, I know what fraud means, and it's my job to charge people with it. The definition of fraud includes deceit, trickery, or imposters. That hasn't happened in Minnesota. Our election process was reviewed under a microscope both in the 2008 and 2010 elections. Former Republican State Senator Fritz Connaught, the man who represented the Republicans in the 2008 recount, repeated again this June what he said a number of times before, and I quote, "There wasn't fraud. There were technical problems. It simply didn't happen. Believe me, we were looking. It was not fraud that elected Franken to the United States Senate," end quote. The extreme groups are also going to tell you that this voter restriction amendment is simple, but it's not. There are extreme consequences for this amendment for soldiers, for seniors, for students, and for local governments. Justice Alan Page declared that the photo ID amendment is a, quote, classic bait and switch, end quote. Justice Paul Anderson in the same case declared this amendment to be, quote, inaccurate, misleading, and deceptive, end quote. These aren't a couple of partisan hacks. These are Minnesota Supreme Court justices, judges who serve in our highest court and uphold our Constitution and laws. It's ridiculous to change our Constitution to restrict voting from our men and women serving overseas, our seniors and students for political gain. As I said earlier, the work this state has done over the last 40 years to improve our election system has always been, up to this time, bipartisan. The most recent example of this was in 2010, when Republican Governor Tim Pawlenty signed a bill overwhelmingly supported by both Democrats and Republicans to move the primary date from September to August. The reason was that the September primary made it too difficult for Minnesotans serving overseas to vote. That action and other improvements made by Democratic Secretary of State Mark Ritchie earned Minnesota an all-star state designation by the Military Voters Project Protection. I will not stand by while this amendment tries to restrict the rights of the very soldiers who are fighting for our freedom overseas. I urge you to do the same. These groups also don't want to talk about the cost to the local property taxpayer. This amendment is being thrown on the backs of our local communities and counties to fund. This is going to cost townships, cities, and counties $50 million or more to implement. And there's an additional cost on top of that for the state. I don't know about you, but spending $50 million on something to solve a problem that doesn't exist doesn't make much sense to me. And at the end of the day, citizens across the state are going to foot this bill through increased property taxes. Frankly, as my former colleague, Jen Olson from the Minnesota Senate would say, communities have enough unfunded mandates as it stands. Furthermore, by putting this into the Constitution instead of by statute, we are locking ourselves in. Again, former State Senator Fritz Knack and I are in agreement. Technologies are changing for verifying voters, but we won't be able to adopt these changes if we adopt this amendment. It's not hard to imagine that 10 or 15 years from now, there'll be superb new technologies and we'll be stuck using the equivalent of a slide rule. More than anything, though, this is un-Minnesotan and unnecessary. Minnesota has always addressed voting in a bipartisan manner, but for the first time in our history, we have outside interests in an overly aggressive Republican legislature jamming this poorly written constitutional amendment down our throats. They got it wrong. They screwed it up by not making exceptions for our men and women in the military and for our seniors and those with disabilities. Now, the folks at Fox 9 News might be okay with restricting our military members, seniors, and disabled folks from voting, but I'm not. And I don't think Minnesota is either. The only election irregularity we've encountered is ineligible voters who are felons voting before their civil rights are restored. By law, I'm required to investigate every instance of suspected voting violations. After the 2008 and 2010 elections, we received a handful of possible violations referred by the Hennepin County election officials and hundreds from the Minnesota majority. When the extensive investigations were completed, we filed charges against 38 people, all of them felons who had voted before their civil rights had been restored. More than 660,000 people voted in Hennepin County in 2008. That means 0.0057% of the votes violating state law. That's pretty small. We went to work and made some reforms, and in 2010, out of 470,000 voters, there were only 11 voter cases that we charged, 10 felon voters and 1 double voting. Voting ID would not reduce felon voters. Minnesota felons, the moment they get out of prison, are eligible to receive a state-issued ID. And indeed, in the cases that we prosecuted, of which I personally reviewed, these felons went to the correct polling place, they lived at the address they said they lived in, and their names were accurate. There was no fraud. They voted, but they shouldn't have because they were felons. A photo ID simply would not have stopped that. Requiring a photo ID would also profoundly reduce election day registration. This is one of the great innovations pioneered in Minnesota by a truly bipartisan effort. In the 2008 election, more than 540,000 people registered on election day. It's a popular program that would disappear under this amendment for no good reason. And don't talk to me about provisional ballots. The simple fact is most people wouldn't go through the hassle of coming back days or weeks later with a new government ID in order to have their vote counted. As I mentioned earlier, Minnesota has a long, proud tradition of bipartisan agreement when we make changes to our election laws. Unfortunately, this time it was different. When the legislature passed the voter ID bill in 2011, it was completely on party lines. When Governor Mark Dayton vetoed that flawed bill, well, instead of working to make it better, the Republicans simply passed it again without a single Democratic vote. This time, it's a constitutional amendment. If it passes, this amendment would be one of the most restrictive photo IDs in the country. Unlike other states, it won't allow military IDs. It won't allow student IDs. And heaven help if you're unfortunate enough to move in the days before election and didn't have time to get your photo ID changed because you'd be barred from voting. Finally, Mr. Fund, who I've met for the first time today, in his book, and friends from Fox News, made a big deal out of illegal voting cases discovered and prosecuted in other states. Again, many of those cases would not have been prevented by photo ID. But in Minnesota, we run clean elections. The 2008 and the 2010 elections were some of the most closely scrutinized in the history of this country. No fraud was discovered. No organized attempts to illegally manipulate the vote. There are a handful of double votes and a few felon voters. In conclusion, this is Minnesota. This is not New York or Georgia. It's not Mississippi. And as the Republican-appointed Supreme Court Justice Paul Anderson thundered during a hearing in the Franken-Coleman case, this is not Florida. Minnesota doesn't need this expensive voting repression of photo ID. And so for the following three reasons, if none others, the photo ID amendment should be rejected by the voters in November. It's unnecessary and restrictive. It's expensive. And it simply will take the vote away from folks who have earned the right to vote. Our military overseas, some of our senior citizens, some of the people with disabilities. It's simply an ill-advised piece of legislation and it should be rejected.